We are on the record.
This is D19. See the whole matter. Let's.
There we go.
Oh, sorry. Are we ready?
Yeah, now we're ready.
Okay.
Got
So
it.
let's see. Let's start with counsel for the plaintiff. Can you hear us?
Good morning, Your Honor. Erick Ferran, 9554 for who's in here with me.
Thank you. And then I see we have Miss Marr there. Miss Marr, did you want to put your appearance on the record?
I will. Good morning, Your Honor.
Good morning.
Patricia Marr, bar number 8846. I'm appearing on behalf of the defendant, who is also present via Zoom.
Right?
And I
Yeah,
apologize,
no,
yes.
that's okay. I just
Thank
wanted
you.
to be sure I had his name right. And you just want to put your name on the record
Alexander
first.
Falcone, the founding director of Our Nevada Judges Incorporated. Attorney Luke Busby is in another courtroom, but I think I can get us through this.
Are you okay without him
I'm
being in
totally
here?
fine with
Are you
it.
sure?
If you're fine with it, I'm fine with it.
It's up to you.
I'm fine with it.
Okay, if you're okay, then we're okay. So, counsel, just in the interest of being transparent, I know we had that recent Nevada Supreme Court decision, and as a result, I'm sure Mr. Falcone has been being rather busy over there. But this is one of the cases in which we did receive a media request and request to unseal. The request to unseal was actually set on Chamber's calendar, but I just wanted to let you know that I believe Mr. Falcone is accurate and that the case was sealed to an extent it should not have been sealed, so I am going to be granting that, and it will be unsealed in compliance with Nevada Supreme Court Rule 35C. So I wanted to give the attorneys a heads up about that. I don't think anyone has any opposition to that because it's just in compliance with the law. But Ms. Marr, Mr. Ferran, do you guys have any concern about that?
I do, Your Honor, I do. And I recognize the public interest versus the private interest. And in this particular case, I don't know why if it's such importance to Mr. Falcone. With that being said, my client does have concerns with the unsealing, given that
Well,
Mr.
Ms. Marr, the unsealing is really to a very limited extent, and it really just is in compliance with the Nevada Supreme Court Rule 3. I think it's 5A, right? 5C, 35C.
5C.
Yeah, and so I don't think we have a choice in doing that.
Right. With that being said, I would request that some safeguards be implemented because at this juncture, given the history of this case, it appears to my client, in any event, that it's more of a personal vendetta versus a quest for information for the public. And in that regard, I would note for the court that Mr. Falcone has been seen hugging the plaintiff after court hearings.
Alex here. We'll talk about this at the end of the video.
So we would request with the court's order today that there be extra precautions taken. For example, there's at times
Ms. Marr, right, so are you talking about the media request in terms of being present during hearings, or are you talking about the unsealing of the record just to the limited extent pursuant to the law?
at this juncture, the unsealing of the records, we'd like, if the court's going to unseal the records, and I understand the applicable law, but that there be precautions taken, because sometimes the titles of the motions themselves or the pleadings are inflammatory and contain erroneous information, just allegations by their very nature. So we would request the court.
My reading, and Mr. Falcone, you probably know it way better than I do, but my reading of it is that it would be the case number, the date the action was commenced, the name of the parties, counsel of record, the assigned judge, the notation case sealed, the case type and cause of action, the order to seal. So it's very limited what would actually be unsealed, correct?
Right. All it does is give me the ability to see the hearing dates and times once that index is restored, which is, I understand some people don't want us to go into a hearing. That's fine, we can litigate that. But to not let us know hearings are even occurring goes way too far. So the existence of the hearings themselves is what I'm looking at.
Correct.
I understand there's inflammatory titles and stuff. The other courts deal with that all the time. And we have our own reputation as news reporters. We don't just go publishing all kinds of nonsense. It damages the corporation just as much as it would damage the court's reputation.
And then, sorry, Mr. Ferran, I haven't heard from you on this point, just the limited point of unsealing to the extent that we are required to do so by Nevada Supreme Court Rule 35C. What's your take on it?
We have no objection, Judge.
Okay. So I'm good. So I will go ahead and grant that, Mr. Falcone, and that will just come off my chambers counter. I'll do the written order for you unless you
Okay.
want to submit it through Mr. Busby.
Yeah.
It's up to you. Do you guys have a standard one you've been submitting or no?
We could start doing that. We do like to take as much of the load off the court's shoulders as we possibly can. If you would like that, we will start a template up because
It seems like that might be prudent, right, if you're doing this
we're
with some
doing it.
frequency?
Yeah, we are. And
Sure.
we'd like to make sure that we don't burden the court to the extent that we possibly can.
Sure, that would be great if you guys want to do that. And if you want to circulate and just be sure that Ms. Marr and Mr. Ferran, so it would be Mr. Busby who'd be circulating it, I
Yes.
assume? Yeah, just be sure that he circulates it to Ms. Marr and Mr. Ferran too, in case they have anything they have concerns about.
Okay.
Okay?
And Your Honor, I would make a request while we're before the court that apparently Attorney Fleming has been filing in the case, and not all registered filers must be e-served by any FCR 9B. So we just want to ensure that happens moving forward.
Attorney Fleming or Ferran?
Yes.
We have Mr. Ferran.
No.
And Judge, she's got the notice of association as well.
I'm sorry, what was that?
He has filed a notice of association and appearance on the plaintiff's side as well.
I can't really hear him. Did he say?
She's filed a notice of association in this
Okay.
case, Your Honor. So
Okay.
moving forward, we just want to ensure that everybody that's registered for the e-filing is served with the pleadings that are being filed.
And who are you directing that comment to?
Well, since she's associated with Attorney Ferran, I guess I just want to place that on the record.
Okay. And then we did go ahead and sign the media request that we received on this case, largely pursuant to that recent Nevada Supreme Court decision. I just wanted to kind of determine from you, Mr. Falcone, I think it was for, and I wasn't really sure exactly what hearings. I think you said the May 14th hearing, was that right?
So in the fine print of the MROR, it's for the hearing that we designate and all other hearings in the case.
Okay.
Now, some judges don't like that, and they would prefer we send one in for each hearing. Most judges hate that, and they like to just sign it once and be done. So if you'd like it to just be for that one hearing, I can submit requests for other hearings.
No, that's perfectly fine if you include all.
It's in the fine print.
Sure.
In the standard
Okay,
form.
I probably just missed that part because I wasn't sure, because I think you sent the order through more than once. So your intention would be to appear for all hearings?
For all, that's our standard policy.
Okay.
We do
And you may
comprehensive.
miss some, I assume, if it's not one you
If
want
we
to
don't know
attend?
where they are, right.
Okay. So, in that regard, Ms. Marr and Mr. Ferran, do you have an objection? And if so, I would allow you time to file a written objection, and then we would schedule that for a hearing.
I do not, Your Honor.
And Ms. Marr, do you?
I'm conferring with my client, Your Honor. Court's indulgence.
Sure.
No objection.
No objection. Okay. So we don't have to worry about scheduling that. And then are there parameters, limitations, such as perhaps using initials for the child's name or anything like that, that counsel would propose?
I would propose certainly using initials, scrambling voices. That's a main concern for my client.
And then, Mr. Ferran, what are your thoughts?
Judge, we're okay with using initials for the child.
Sure.
Fine.
And I wasn't sure about Ms. Marr's scrambling voices. Whose voices is it that you feel you need scrambled?
Blurring faces, scrambling voices, for certain witnesses that we just don't want the child in this case being subjected to testimony that may be harmful in the future. She sees it on the news or it becomes public.
That's rather vague. So are you anticipating you will just bring this up on a hearing by hearing basis, depending on what witnesses would be present then?
Perhaps it would be better suited to address on an individual basis,
Sure.
because I agree with you. It is vague at this juncture.
Okay. Yeah, I mean, I think if we could, you can bring it up at the start of the hearing, if there's certain witnesses that you would prefer, you know, have their voice altered or their appearance blurred, you can let us know, and then we can let Mr. Falcone know. Is that something
Perfect.
you can live with too?
Well, I do, on the voice.
And you would have the option to object, obviously, but,
Right. Yeah. We do the redaction of the faces and the names. We've never done voice modulation. I guess we
Okay.
can talk about that. The thing is, keep in mind, like, that would be for somebody who's in danger. I mean, if we redact the name audibly and visually, that protects their identity. Like, the voice modulation is like a source who's like, might be assassinated or something. The viewers will notice, and it'll make the government and us look bad if it goes a little over the top. Like, if we protect kids, the viewers are happy. If we go way over the top and we're like a FISA court, they start to get all weird. So, I mean, to the extent, I would object to that, but if the court orders it, I think we could probably do that.
yeah, so we'll just wait and see on that, because I don't know obviously exactly what's coming up, so I recently inherited this case, so I'm not exactly sure what all we have coming up, but I see there's a lot. So we'll just do it on a hearing by hearing basis, okay? But certainly for the child, we don't want to have her name out there, so we'll use her initials for sure. Okay? So that was really the purpose of the hearing from my end. I just want to be transparent and square that all away with everybody. Anything else, counsel, you thought we should discuss?
Not at this time, Your Honor.
Oh, yeah.
No? Okay. All right. Thank you so much.
Alex here. As promised, the hug thing is really, on the one hand, because it's family court, I guess I shouldn't be surprised that I got a little bit of family court on me. The family court lawyers are known for doing stuff like that. The hugs are not very common when it comes to Brittany and I or anybody else on my staff, but they do happen sometimes. And I think it's just because the litigants in the cases are in a very emotional state, and that's how they take it out on us sometimes. They gave us a hug. This happened as recently as Roger Hilligus, Stuart Hanty sentencing. So when it happens, it just happens, and we just kind of let it happen, and they don't get any special treatment for doing that. We don't know the mom or the dad in this case any more than we know Roger Hilligus or Stuart Hanty. It's just something that apparently happened, and Patricia Marr thought would be a way to thwart camera access. The other thing I'll talk about, I guess, is the voice modulation thing. I think in the court, I was so caught off guard by it that I kind of made it look like the dad's concerns were invalid. In hindsight, the dad's concerns are not invalid. There's just a whole bunch of other things that I have to think about before I say yes to that. What are the viewers going to think? How much more work is it going to be from editing? And I know that I use an extreme example in the hearing of a person potentially being in a life-threatening situation. There are other situations where voice modulation is used, like if somebody might get fired from a job. But there's a lot more that goes into it. You don't just give anybody that kind of extra effort, and it's not just effort. I do think that it'll have an impact from the viewers. I do think people will be weirded out by it. I do think that in some situations, if I was ordered to do that, I'd just probably cut the audio out. There has to be an issue that is so pressing and interesting to the viewers that they're willing to tolerate that. So it's a very thorny topic for me right now, but I did want to at least say that the dad's concerns were valid, and whether or not we do something like that, I'll probably end up making some kind of system of policy or rules behind it rather than just doing voice modulation to anyone who asks for it. Hopefully that makes sense to you guys. I guess if you have any questions, go ahead and post them down in the comments below.